Without any crime cited, the impeachment of President Trump is doomed to failure in the Senate. Hello, this is Robert Romano, Vice President of Public Policy with Americans for Limited Government, dailytorch.com. Hit that subscribe button. Today, we're going to be talking about the arguments the House is presenting in the U.S. Senate for removing President Trump from office. The articles of impeachment are abuse of power and obstruction of Congress. But these are not criminal violations that you can find in a statute passed by Congress or a state legislature or anything like that. These are basically expanding the definition of the Constitution for what is supposed to be treason, bribery, or other high crimes and misdemeanors. And the president's attorneys, President Donald Trump's attorneys, in their trial memoranda, take this issue head on. Quote, House Democrats settled on two flimsy articles of impeachment that allege no crime or violation of law whatsoever, much less high crimes and misdemeanors as required by the Constitution. The terminology of high crimes and misdemeanors makes clear that an impeachable offense must be a violation of established law. The impeachment clause does not confer upon Congress a roving license to make up new standards of conduct for government officials and to permit removal from office merely on a conclusion that conduct was bad if there was not an existing law that it violated. That's the president's brief in the Senate noting the fact that the two articles of impeachment, abuse of power and obstruction of Congress, are not criminal violations under either federal or state criminal codes, and they are not treason and bribery. Yet Article 2, Section 4 of the Constitution is very plain that the president and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Article 1, Section 3 anticipates that presidents removed from office or other officers would then be held liable for prosecution for crimes that are, prosecutable. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So here the constitutional framers were anticipating that a president who's impeached would then face prosecution upon being removed from office. And so I think that settles very clearly that they thought of impeachment as a criminal matter, besides the text of the Constitution itself, where they cite crimes, very specific crimes, treason and bribery, but also other high crimes and misdemeanors, all again indicating that it has to be a crime. If you don't have a crime, then your impeachment could be held to be constitutionally invalid. If you look at Federalist number 69 by Alexander Hamilton, on impeachment, it says the president of the United States would be liable to be impeached, tried, and upon conviction of treason, bribery, or other high crimes or misdemeanors, removed from office, and would afterwards be liable to prosecution and punishment in the ordinary course of law. So again, if you don't have a statute that the president is said to have violated, the impeachment is actually unconstitutional. These articles of impeachment that the Democrats brought, abuse of power and obstruction of Congress, they don't meet that threshold. They are not high crimes and misdemeanors, and therefore the Senate should be moving for a swift dismissal. I think one of the president's attorneys, Alan Dershowitz, argued vociferously on the Senate floor on this very count. Let's take a listen here.
Because the issue today is not what the criteria of impeachment should be, not what a legislative body or a constitutional body might today decide are the proper criteria for impeachment of a president, but what the framers of our Constitution actually chose and what they expressly and implicitly rejected. I will ask whether the framers would have accepted such vague and open-ended terms as abuse of power and obstruction of Congress as governing criteria. I will show by a close review of the history that they did not and would not accept such criteria for fear that these criteria would turn our new republic into a British-style parliamentary democracy in which the chief executive's tenure would be, in the words of James Madison, the father of our Constitution, at the pleasure of the legislature. The conclusion I will offer for your consideration is similar, though not identical, to that advocated by highly respected Justice Benjamin Curtis, who, as you know, dissented from the Supreme Court's notorious decision in Dred Scott, and who, after resigning in protest from the High Court, served as counsel to President Andrew Johnson in the Senate impeachment trial. He argued, and I quote, "There can be no crime, there can be no misdemeanor without a law, written or unwritten, express or implied." In so arguing, he was echoing the conclusion reached by Dean Theodore Dwight of the Columbia Law School, who wrote in 1867, just before the impeachment, "Unless a crime is specifically named in the Constitution, treason and bribery, impeachments like indictments can only be instituted for crimes committed against the statutory law of the United States." As Judge Starr said earlier today, he described that as the weight of authority being on the side of that proposition at a time much closer to the framing than we are today. The main thrust of my argument, however, and the one most relevant to these proceedings, is that even if that position is not accepted, even if criminal conduct were not required, the framers of our Constitution implicitly rejected, and if it had been presented to them, would have explicitly rejected, such vague terms as abuse of power and obstruction of Congress as among the enumerated and defined criteria for impeaching a president.
So there you have it. Not only is a criminal violation required in order to sustain an impeachment and to have the president removed from office, even if that weren't the case, the criteria that the Democrats have put forward in the House of obstruction of Congress and abuse of power would have been explicitly rejected by the framers had it come up at the Constitutional Convention, because, and as Dershowitz goes on to argue, things like maladministration were explicitly rejected at the Constitutional Convention, and they settled on the narrow high crimes and misdemeanors, treason and bribery as the sole criteria for removing a president from office. And I think that really settles the matter. So basically, having failed in their most basic obligation to charge the president with a crime in order to have him removed, House Democrats should not be surprised that they face now an uphill battle in the Republican-controlled Senate, which was already skeptical of the charges that allege President Trump abused his power when he temporarily paused military assistance to Ukraine while he considered a rescission or deferral of funding from Congress, namely because the president has the power to consider such rescissions and deferrals, and otherwise under Article 2, the president is in charge of foreign policy. He's allowed to condition military assistance in exchange for other policies that are going to be favorable to U.S. interests. And combating corruption, particularly potentially involving Americans in Ukraine, I think is in U.S. interest. It's in the interest of the law. We have a mutual legal treaty with Ukraine to cooperate in legal matters. So if there's corruption or bribery or whatever going on with this Burisma, for example, natural gas firm that Ukraine was investigating and Hunter Biden was serving on the board of directors of, and then Joe Biden's bragging about getting a Ukrainian prosecutor fired, well, it may be in the interest of even a subsequent administration to look into that, to ensure that U.S.-Ukrainian relations are not undermined by this corruption from U.S. administration, and to ensure that it never happens again, that there aren't such conflicts of interest. That's what happened here with President Trump. He raises the issue of the Bidens as it relates to, gee, did you complete your Burisma investigation? Did your prosecutors have a fair go at it? Or did Joe Biden interfere with that? You might want to take another look at that. Raising that with the Ukrainian president, Volodymyr Zelensky, on July 25 in the phone call, not a crime, and certainly not a prosecutable crime. In other words, if the president wasn't the president and this had occurred in some capacity, could he be brought up and charged with the crime by the Justice Department? The answer is no, because these are not crimes. And certainly talking to foreign leaders is a part of the president's job. And otherwise, the president has the power to consider these things under law. So you have here proposed deferrals of budgetary authority under the U.S. Code. You have proposed rescissions of budgetary authority to Congress under law. You have apportionments, which is what the Office of Management and Budget did when it temporarily paused funding for military assistance to Ukraine. And so that was paused while the president was considering a potential rescission of the budget authority for the military assistance. But I don't even know that this is vital military assistance to Ukraine. I'm sure military experts might disagree, but fact is this stuff's been, these Javelin missiles have not been shot at a single Russian tank. They haven't blown up any Russian tanks with it. And as far as we know, it's sitting in a warehouse in western Ukraine, far away from the eastern front, in the Donbass region and Crimea, etc., in the Ukrainian civil war that's pitting Russian forces, pro-Russian forces, against pro-Ukrainian forces. And otherwise, Ukraine is not even a member of NATO. So are we under obligation to defend them if the president determines that doing so might endanger national security, risk a wider regional war? I think the president has the power under Article 2 to avoid World War III with Russia. And we would expect that, just like we expected it of Ronald Reagan or John Kennedy. That's what we want, presidents to keep us out of that, because it's catastrophic. It means the potential end and extinction of humanity. In any event, the military assistance that's under question by September 11, 2019 was already approved. The freeze was lifted. And so there isn't a basis for saying that the funds were even withheld, because the funds have already been delivered. On the broad constitutional question of administering foreign policy, if the president believed military assistance risks such a wider regional war, he was absolutely within his powers to try to either condition the military funding to ensure that it would be utilized in a manner that doesn't jeopardize national security. If he was concerned about corruption, to ensure that the funds would not be mishandled, or that the Javelin missiles would be misplaced or lost or stolen or whatever because of corruption. So I think you have a powder keg there. You have corruption issues there. These are legitimate things for the president to look at. But not only are these considerations not crimes, and I'll leave you with the close here, they are things the president expressly has the power to do under Article 2 of the Constitution, sole vesting of executive power in the president. Whether they are good ideas or not, or why they were being considered, are not relevant to a constitutional discharge of the president's duties, which is why a crime is needed in order to have a president removed from office. Without one, an impeachment cannot be held to be valid. And therefore, once the House and the president's legal teams have had the opportunity to present their cases, we're into questions now. The Senate should move for a swift dismissal of the charges and acquittal without any crimes. What do you need witnesses for? That's the commentary. This is Robert Romano, Vice President of Public Policy with Americans for Limited Government, dailytorch.com. Hit that subscribe button, ring the bell for notifications, and have a good day.